As of September 2025, the Florida Supreme Court has amended the rules on pretrial release and bond. So what does this mean for you? It means that if you or a loved one is arrested, you might get out of jail faster and on fairer terms. Let's discuss the potential advantages of these new amendments surrounding bail and pretrial release in Florida. So the first big advantage, get me out of jail faster. Well, judges can now rely on local or uniform bond schedules to release defendants even before their first court appearance. And that means, depending on the crime, you might not have to sit in jail for 24 to 48 hours waiting to see a judge in first appearance court. And once you get out, now you need to fight this case. You need to hire a lawyer. You need to go through the process. So if you don't hire a lawyer, well, you will get a court date in the mail and you'll need to be there for that court date. But what you should do is hire the best criminal defense lawyer that you can as early as possible, because they can then start working, attacking and fighting and defending you right away, especially in the pre-file case. I know we have other videos on that pre-file process. So we'll link those up here as well. Another benefit is clarity and predictability within the criminal justice system. This enhances clarity and predictability by a codified non-monetary conditions list. So the updated rules now provide the exact list of non-monetary conditions. So things like travel restrictions, supervision, monitoring, instead of vague language. And this gives defense attorneys clear ground to argue for release conditions that make sense to each client. So it's not like, well, one judge really doesn't want you to travel and another judge wants everybody on an ankle monitor. So really, now that all of the different things are there, the defense attorneys have better arguments, especially now that the rules of procedure say what can and should be argued and considered by these judges. So that's going to help a lot. Great defense lawyers have the ability to challenge excessive bond at first appearance. Now, we've always had this ability, but now that there is a specific bond schedule for certain crimes, it still does not take away our job to come in and say, Judge, yes, there's this bond schedule, but it's still too high for this particular client, and here's why. So we've always been able to do that, and we're still able to do that despite the procedural rules change of these now standard bond, monetary bond amounts and conditions. And what it also does is it levels the playing field across the state. So somebody who gets arrested for possession of drugs in a small town is going to get treated much more similarly to somebody who gets treated with the same amount of drugs in Miami or Fort Lauderdale. And for this, these small podunk towns, what they would do is they would have sky high bail because they didn't want people bringing drugs or coming into their little community. Okay. I mean, it is what it is. And now people are going to be treated much more uniformly and fairly all across the state. So there's not going to be any surprise numbers or ridiculous bond or bail amounts just because of geography, because you went down the wrong road on the way to Disneyland. So if you want to get out of jail before you ever see a judge, you'll need to post the scheduled bond. Non-monetary release options, things like ankle monitors, no contact orders, or reporting requirements usually don't kick in until your first appearance hearing, when a judge can tailor those conditions to your situation. In most cases, we don't want those conditions. Those conditions are a lot harsher, and there's a lot of things to impose on our clients. So if our clients can bond out with the uniform bond amount, we want them to. If they can't afford it, well, then we're going to go ahead, we're going to be there, we're going to argue for bond reductions and maybe some non-monetary conditions as a way to lower the bond conditions so our clients can get out. These updates create real opportunities for defendants and their lawyers to secure faster and fairer release. We're going to have some more videos coming up discussing additional challenges and risks that these new rule changes can bring as well, so stay tuned.